Hello there, I'm attorney Kelly Longtin, founder of Kelly Longtin Law, where we provide effective estate planning for everyday families. So today I want to share this video with you, yours, mine, and ours, and how including a pour-over trust can simplify your planning for your family. Now, a number of married couples think about their accounts and their property as yours, mine, and ours, especially if either or both spouses have gotten or will be getting remarried, married later in life, or have brought or will be bringing significant amounts of money into the marriage. Now, deciding what should happen to all of those accounts and property at death, that can be a big undertaking for some families. To help alleviate some of the stress that may come with making such decisions, I'd like to suggest a unique estate planning tool called a pour-over trust. What is a pour-over trust? A joint pour-over trust holds you and your spouse's joint property, so it's a joint trust. You can create the joint trust together and name yourselves as the current trustees. And then when the first of you passes away, half of the joint trust assets and property is distributed, pours over, to the deceased spouse's separate trust, and the other half is distributed to the survivor's separate trust. So does this mean that you're going to need 3 trusts? Well, for the estate plan to work as intended, you may indeed need 3 trusts. Jointly owned property goes into your joint pour-over trust, and separately owned property goes into your own separate trust. This allows you to provide instructions, separate instructions, for handling jointly and separately owned accounts and property. However, once the first of you dies and the accounts and property are distributed to their respective individual trusts, there is nothing more for the joint pour-over trust to do. Thus, it won't require a long ongoing administration after the first spouse passes away. So let's talk about what some of the other benefits of a joint pour-over trust are. The ease in funding the trust. A joint pour-over trust makes it easier to fund your joint accounts and property into it because both of you can control it. While an account can be jointly owned by 2 people, some financial institutions may not allow 2 trusts to jointly own the same account. This technically can sometimes derail your planning or increase the risk of probate should the 2 of you die simultaneously, while still owning your accounts and property jointly as individuals. Another benefit is the ease of administration. The joint trust allows for ease of lifetime administration because both of you retain control over your joint property. Another benefit is probate avoidance. Avoiding probate is a popular reason for considering a trust-based plan. If your joint accounts and property are in a trust and you and your spouse pass away simultaneously, your loved ones can avoid probate because the trust instructions will dictate what happens to your accounts and property. Your chosen backup trustee will carry out the instructions without court supervision. And another benefit is keeping things separate. So by allocating your joint property to the joint pour-over trust in your separate accounts and property to your individual trusts, your separate accounts and property remain separate, and it is easier to administer the trust according to each of your wishes. Such an arrangement can be helpful if you or your spouse have children from a previous relationship whom only one of you wants to provide for at death. In some cases, however, these accounts or pieces of property may have already been handled separately, so commingling them in a joint trust may muddy the waters and run contrary to your desires. And let's talk about a double step-up in tax basis. In a community property state, placing your joint accounts and property in a joint pour-over trust may enable the 2 of you to preserve the community property nature of your accounts and property, allowing for the double step-up in basis once at each of your deaths. If you were to divide ownership of these accounts or property between 2 separate trusts, you may risk losing that double step-up basis. Now, having joint and separate accounts or property does not mean that you cannot carry out your estate planning wishes. Working together, we can assess what you own and how you own it, and discuss your wishes about what should happen to those accounts and property at your death. So give us a call so that we can help you create and craft a plan that works best for you and your spouse and the rest of your family. So I'm attorney Kelly Longtin. I want to thank you for watching. I hope you found this helpful. I'm founder of Kelly Longtin Law, where we focus solely in estate planning. And we're glad that we are able to provide effective estate planning for everyday families. So I hope you found this beneficial. There's lots of other educational videos that you can watch on our YouTube channel. And I look forward from hearing from you guys to help you with your estate plan and with your family.